All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh, give their attention to the court. Now sitting.
Please be seated. Good morning, everyone. Welcome to the Kansas Supreme Court. For those of you that are unfamiliar with the court's processes, I'd like to take just a minute or so to explain to you that the justices are familiar with the facts of the case. We have received briefs from the parties and read those, as well as looked at the authorities relied on. We've looked at the records that were developed in the district court and otherwise prepared for this morning's argument. So we're looking forward to hearing the oral argument of the attorneys and having an opportunity to have an exchange with them as they answer questions we might ask. I will also explain that you'll notice some of us have computers in front of us, others of us have stacks of notes. You will find us looking at those at times during the argument. I just want to assure you that when we're doing that, we are consulting material about the case to help us understand the argument that the attorneys are making. We remain focused on the oral argument when we are doing that. And we may be taking notes about the arguments that are made. So with that, I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
The first case on the 9 a.m. docket for Tuesday, May 16th, 2023 is appeal number 123833 in the matter of the parentage of R.R. Barton County, briefs both sides.
Jeffrey Lowe for the petitioning party and appellant T.T. who is present. I am present and ready for argument.
May it please the court. My name is Tish Moracle. I'm from the law firm of Hampton and Royce in Salina. I am here for the appellee T.R.
Second case is appeal number 124116 in the matter of the marriage of John Holliday versus Tamara Holliday, Jackson County, briefs both sides.
May it please the court, Cecilia Mariani. I represent Tammy Holliday. She is the petitioner and the appellee, and I am present and ready for argument.
Good morning. May it please the court. My name is Shauna Miller of Joseph Hollander and Craft here in Topeka. I appear on behalf of my client, John Holliday, the appellee in this case. I am present and ready for argument today.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. Now ask the attorneys in 123833, the matter of parentage of R.R. to please come forward. Settled, you're welcome to come to the lectern in your argument.
And Jeffrey Lowe, may it please the court, for the petitioning party and appellant T.T., again, who is present. I am present and ready for argument. I would ask for 3 minutes of rebuttal time if it would also please the court.
3 minutes is granted.
Thank you. The first issue I want to address today, which is issue 1 identified in T.T.'s supplemental brief, is the Court of Appeals erred in failing to recognize that the district court abused its discretion in deciding that certain individual factors used to determine the best interest of the minor child favored T.R.
Now I'm going to interrupt you right at the get-go.
Sure.
Okay. I'm struggling with this. We've never adopted the Greer factors, right?
We.
The Supreme Court. There's been no Kansas Supreme Court decision adopting the Greer factors, correct? Right. And the Greer factors came about as a result of the statute, right? In reading the original Greer decision, it was talking about, that they remanded it back to the district court to consider what is in the statute. And that is if two or more presumptions under this section arise, the presumption on the facts is founded on the weightier considerations of policy and logic, including the best interests of the child shall control.
And you're referring to KSA 2308.
2208 subsection C. Correct. So that's what that's the statute. The legislature has said, look, you need to weigh policy and logic, including within that, the best interest of the child. And then the Court of Appeals said, we're going to remand this, and it's a relatively new case. We're going to remand this and then citing a law review article or something, I think by Professor Elrod said, here's some 10 factors that could help you do that, right?
They gave those 10 factors to help give consideration to policy and logic.
Right. So, so the question is, do you believe there was an abuse of discretion by the district court judge in relying exclusively on those factors instead of considerations of, do you think that, and I don't blame the district court. They're like, okay, we've got this Greer decision. I'm sitting up here looking down on the Court of Appeals. They're looking up at the Court of Appeals. So it's a different perspective, but the district court felt like, okay, we have to follow these 10 factors, right?
And the district court said so on the record that we
Right.
had to follow.
Right. Do you think that that was error to limit it to those factors when really the statute is more broad?
We're not saying, Judge, that in and of itself is the error, that he was limited to just the Greer factors. But to give you an analogy, when the court looks at in the domestic realm the issue of spousal maintenance, the only guidance our legislature gives on the issue of spousal maintenance, alimony, is as justice and equity so require. And then we have other cases that have interpreted what does justice and equity
Right.
mean. And you have the Baumgardner case and the Williams case.
But do
and the
you
Hare
think
case.
that the district court limited its analysis to the 10 Greer factors?
Yes, and also the ancillary
Right.
issues as well. The
Okay.
court said so.
Okay, so, and
And on that note, Your Honor, if the legislature in Kansas had a problem, Greer is a relatively new case, but it's 2017, I believe. That's been 5 years. And the
well, and in
legislature-
2017, the
Correct.
Kansas Parentage Act, the Uniform Act, they totally revised it, and that was before the legislature in this session, right?
Correct, but what didn't they do? They didn't expand
Oh,
on.
yeah, they
statutory-
gave explicit factors. Have you,
Well, yes.
I mean, they said their own factors that would replace the Greer factors, which would be the age of the child, the length of the time during which each individual assumed the role of parent of the child, the nature of the relationship, the harm to the child if the individual is not recognized, the basis for each individual's claim to parentage, and other equitable factors arising from the disruption of the relationship between the child and each individual. And then there's a whole section B about genetic parents.
Correct, and that came after Greer. And if you look at those statutory factors, they're very similar to the Greer factors. They're very similar to what Professor Elrod sets forth in her secondary authority. They're very similar. Granted, is there exactly 10? No, but look how many similarities are with those statutory factors in Greer. And I think that's important. So whether you apply exactly that statute or the Greer factors, you still get to the same end of the road analysis that the court is required to make.
Well, kind of, because it seemed to me in reading the district court's memorandum opinion that it really wasn't like a totality of the circumstance. I mean, he did say that. I'm looking at the best interest of the child, right? But it seemed like this factor weighs in this person, this factor weighs in this person, this factor weighs in this person. And in fact, that is, the basis for one of your claims to us is that some of those factors don't actually weigh in favor of TR, but instead in favor of TT.
Yes, and if you look at the centerpiece of our argument, we understand that this court is not going to reweigh evidence. And therefore, if we looked at just the abuse of discretion standard, if the court felt as though there was been misapplication of the facts, the law, the court can, when facts are not in controversy, look at those.
What is the
de
law?
novo. The law now or the law then?
The law and the statute.
We've talked about what that law is, and that is to give consideration to policy and logic, including the best interest of the child as to which presumptions control.
Okay, and then what policy? Well, I guess I would say, all right, I'm gonna let you go on with your argument. I have a lot more questions, but you deserve to have a chance for your.
No, that's fine. The Greer case gets us some further analysis, just like when we're dealing with the issue of spousal maintenance and what does justice and equity mean? And that's what the court did. We need further guidance, we as the district court, as to what consideration to policy and logic, including the best interest of the child, mean. He looked to Greer, and that's what the district.
Right, but that kind of hurts your position, because if you're saying that the Greer factors help interpret that and that we should adopt the Greer factors, then based on an abusive discretion standard, we would have to find on weighing each one of those that no reasonable judge would find different. That's a pretty high standard.
I spent a significant amount of time in our supplemental brief going through each of those standards, and I'd like to talk about some of
Okay.
those. Factors 4 and 8 from Greer deal with biology. Okay. This man's goose was cooked before he ever stepped in to the first day of trial. How do we know that? The district court early on in its decision says, quote unquote, "Court will discuss this more fully below, but the court is of the opinion that no evidence presented at the hearing would compel the court to believe that it is in the best interest of the child to undo the current legal status of TR as the child's father, despite the biology of the child." District court had a bias against the biological father. I'm not saying the court did something intentional, did something malicious, did something grossly inappropriate. It's a subconscious or unintentional bias.
Is that an error of law, an error of fact, or no reasonable judge would find that way?
It would be both. If you misapplied the facts of the case to the law, that would be a de novo review.
Right, but I'm just saying, you're saying bias.
A subconscious bias, again, favor legitimacy, a child born of a marriage versus the biological child, father.
Right, but is that an abuse? I mean, is that an error of fact? Is that an error of law? Or is that no reasonable judge would have a bias?
It is absolutely an abuse of discretion.
Right, but
Because
which one of those is it? Those are the three things where you can find abuse of discretion.
it is misapplying the facts of the case to the law. Reading something into the law that does not exist.
So it's an error of law.
Correct. And also that misapplication of the facts to the law would be the abuse of discretion. And the reason that we know this is the court wrongfully, and this does get into the second issue of sorts, relied upon the voluntary acknowledgement of paternity. One of the heartburns that I have when you read the Court of Appeals opinion with regard to the birth certificate versus VAP issue, voluntary acknowledgement of paternity, is they all but say no harm, no foul. Well, the court meant birth certificate and said VAP. That dog does not hunt because the statute that the court relied upon, the legal authority for creating a legal parentage, comes from the voluntary acknowledgement of paternity statute, not a birth certificate statute. And you can't just say, well, they're synonymous. They are absolutely not synonymous. You can look at any standard birth certificate and a father does not have to, nor is required to sign a birth certificate. You look at who signs a birth certificate, it is either parent or a third-party informant. Sometimes, depending on the health and condition of the parents, the mother in particular, it is a third-party nurse or attendant that signs the
Okay,
birth
so
certificate.
you're talking about 23-2208A4. The man notoriously or in writing recognizes paternity of the child, including but not limited to a VAP, a voluntary acknowledgement, under 23-2223 or 65-2409.
Correct.
When you go to 23-2223, they're talking about a birth certificate.
Okay, and then you go to the 2209, and it limits the time to revoke a VAP, and that's what the court relied upon. The court relied upon the 2209 saying, listen,
You mean
The-
2409? What?
2209 limits the
Oh,
times
okay,
to
sorry.
revoke.
Mhm.
And if you look at 2209, your honor, it says the person who seeks to challenge the permanent relationship that is created by a VAP, if he's not or she is not a signatory, that person is not bound by its terms and may have standing under the other statutes, which we just talked about, competing presumptions of paternity, to assert a competing presumption of paternity.
Let me just, I'm so sorry for interrupting you so much, but I had so many questions. Did your client notoriously or in writing recognize paternity?
No, he did not sign.
Would you say, no, I'm not, it says including but not limited to a birth certificate. So under A4, would you say that when he filed his petition for paternity at the 3-month mark or whenever it was, that that is notoriously and in writing recognizing his paternity?
My client?
Yeah.
Sure.
And the court didn't take that into account, right?
Court's not on the record of taking that into account. The problem with the birth certificate is.
This isn't a birth certificate. I'm talking about, in looking at this, you're looking at presumptions. And the district court said it was a presumption that TR was on the birth certificate. But isn't there a presumption also because your client notoriously and in writing recognized paternity of the child at the 3-month mark by filing this petition?
Sure.
Thank you.
The problem that I have with your line of questioning and with the Court of Appeals is there is no facts and evidence, and you can look at the record that TR signed a birth certificate. Him being listed on a birth certificate, Your Honor, is not the same as him signing the birth certificate.
He didn't sign the birth certificate?
There's no evidence of that. The record is not replete of that. And what the court is hanging its hat on is that he signed the voluntary acknowledgement of paternity. And look at,
Was there what did he sign?
there's two different things. If you look at,
Right.
there's a voluntary acknowledgement of paternity.
And when did he sign that?
He signed that at the hospital, is what the record says. Not the birth certificate, at least according to the record. I'm not going to represent as fact that he did or did not, but that's not what the record is replete of. So to say that, well, he signed the voluntary acknowledgement of paternity, therefore that's the same as signing the birth certificate, no harm, no foul, is completely a factual misnomer and is contrary to the statute. When you look at a voluntary acknowledgement of paternity, it has much more weight than a birth certificate. And we get into the analysis provided for under KSA 23-2209 in terms of what you can and cannot do. Also in terms of time, whether you can revoke that acknowledgement of paternity. Don't take my word for it, take your own court's word for it from the Smith case from this court. That's the State versus Smith case 306 can 40. In that case, this very court explained that KSA 23-2203 requires hospitals to participate in a VAP program, commonly in the form of consent form for birth registration. It provides a simple process for establishing paternity. However, if he was not the signatory to that VAP, he is not bound by its terms. And the Smith case tells us that. He is allowed to go into court and present, I have presumptions of paternity, including but not limited to his biology. He didn't just have the biological presumption as to why he was RR's father. He had others. That was one. But what was the problem from day one? No evidence that he could have presented. Biology or anything else would have changed the court's mind. It was stuck on the VAP because it assumed wrongfully that because TR signed it, the court is stuck with it. It's in the opening ruling from the court. The man never had a fair day in court to.
What can you, I'm trying to track the argument, but I'm losing the thread
Okay.
of your claim, as at least as I understand what you just said, that this was essentially not a fair hearing below because the judge had his mind made up and didn't even listen to the evidence.
I don't think that was the court's intention. I think that's that subconscious, unintentional bias.
Point me in the record to what you're relying on to draw that conclusion.
if you look at the written opinion, it flat out says, quote, that TR is currently the legal father of the child, end quote. That TT bore the burden of presenting evidence that would, quote, compel the court to believe that it is in the best interest of the child to undo the current legal status of TR as the child's father, despite the biology of the child. And throughout the opinion, the district court reiterates that none of the evidence on any of the factors, the Greer factors, has convinced the court to, quote, take away the relationship of the father from TR and give it to TT.
And why is that legally error?
Because TT never signed the VAP.
Well, but why does that matter?
Because this court has ruled that if he did not sign the VAP, he is not bound by it. He is allowed to come into court and give the court through
Right,
evidence.
but isn't the structure of the Parentage Act one in which there's a burden shifting that goes on? And are you saying that the district court erred by pinning the burden on your client? The burden of one side or the other has to have the burden.
Correct. And it was my client who had the burden.
And isn't that all the district court's saying? Is the district court's basically saying, look, the biological father has the burden to demonstrate that the factors of policy, logic, and best interests weigh heavier in favor of the presumption, that the biological presumption.
I wish it said that, Your Honor, but that's not what it says. It says right from the get-go, there was nothing this man could do to overcome its understanding.
That's where I lose the thread, because read for me from the district court where the district court said, there's nothing you can do. I just don't see that. And that's where I'm, that's where I'm losing the doubt.
And in fact, he even qualifies that isn't what he did, that he did look at the factors. So yeah, point to where that occurred.
Well, I can do that on my rebuttal. I'll go pull the statement of relevant facts where I cite to the record. I didn't bring that
Okay.
back in my, I will do that. I can absolutely do that and point you to the record on that, Your Honor. And we'll do so.
But to add to that, to clarify your argument, is the fact that he was married to the mother at the time not sufficient to cause that statement to be correct, that he was the legal father until the burden shifted or was met after the burden shifting, so that somebody else was determined to be the legal father?
Court in its record relied upon the signature of the VAP as to the statutory framework for establishing that legitimacy and legal rights as TR as being the father. And what I'm telling the court is you can't go in blindly and thinking that this man has no opportunity to present competing presumptions of paternity. That's all I'm saying. The VAP, had it been signed by TR and he waited in time to come into court and say, I don't want to be the father, there are other presumptions from another man, he would have been barred. And that would have been a legal adjudication as to paternity that he would have had to overcome, not TT. TR, but not TT. TR is the one who signed it. TT should have been given, under the statute for competing presumptions of paternity, the fair day in court to say, here are all of my presumptions. And he, yes, would have carried that burden with clear and convincing evidence.
That's just what I thought actually happened here. So if you can on rebuttal demonstrate that that didn't happen, I'll be interested to see.
And if you would look at our petition for review, and also I will pull it from the original statement of facts that I incorporated by reference from the Court of Appeals. On my rebuttal time, I will pull that, Justice Stegall, and I apologize not having that with me. On that note, the reason I think it's important as to why non-married people should be given their day in court is our statute in Kansas. Our legislature tells us that they're entitled to their day in court. KSA 232206 further supports the fact that the presumptions should be given equal footing by stating, quote, the parent and child relationship extends equally to every child and every parent, regardless of the marital status of the parents, end quote. Because again, TT did not sign that voluntary acknowledgement of paternity, he was required, our Smith case tells us this, to be able to present competing presumptions of paternity. He carried the burden. He had to do so with clear and convincing evidence. The two factors that the court completely disregarded because it flat out says biology can't overcome this legal status of TR are as factors 4 and 8 from Greer. The court kind of dismisses, well, the age of the child, so biology doesn't matter. There's no age requirement under that factor. And under the new factors that Your Honor mentioned under the statute, they didn't put a qualifying age limit. You know, consider.
That goes to the question of whether the best interest of the child and the policy considerations and the logic is to be determined at the time of the hearing, or whether you consider until the child turns 18, right?
Right, and if the legislature wanted to put a time limit on it, could. We have an analogy on that. When
But
we look
age
at-
isn't in right now. I mean,
Correct, but the court found age to time bar
as part of the
my
agreement.
client, and that's
Well,
that is an abuse of discretion. He said something about the child being of 18 months old doesn't matter, doesn't recognize its own biology, but it might later down the road. And our statute, when it looks at custody issues, has now added that the desires of a child matter if, quote unquote, of sufficient age and maturity. So our statute actually can recognize age or maturity of a child when considering some sort of factors of equity or best interest. And that's a custody example that I give. I see that my time is up.
I'd still like to clarify, my exchange with you and some others based upon the language of the district court's decision. And I'm looking at page 3 of the district court decision. And there he says that TR was married to the mother at the time of birth, and he has acknowledged his paternity in the application of the birth certificate. So he didn't rely on signing the birth certificate, but the application. And as I asked, wasn't he also looking at the marriage being in place at the time of birth? So why is not signing the application? I've heard you talk about the birth certificate. Was that not in evidence? Was the application not in evidence?
I'm going to tell you, I have reviewed that record on appeal. I did not try the case. I was hired on the appeal. I have not seen evidence of the application of a birth certificate signed by TR. I believe, Your Honor, as an officer of the court, again, the court has confused the voluntary acknowledgement of paternity.
I
That's the
understand that
father.
argument. I'm just trying to pin down, clarify the facts that we're talking about. And then he goes on to say that it's the duty of the court to take into account the Greer factors and any other factor relevant to the best interest of the child. And then I think this was the sentence that you were focused on that may answer your exchange with Justice Deagle. This court will then discuss this more fully below, but the court is of the opinion that no evidence presented at the hearing would compel the court to believe that it is in the best interest of the child to undo the current legal status
I did read.
he has despite the biology of the child. So isn't he really focused on the best interest of the child? Is that not the appropriate standard?
If that's the case, why add that sentence?
I think, I don't know. I read that as saying the biology doesn't trump everything. Best interest of the child is still at play.
And the problem with that is if you further read the court's ruling, he talks about biology being the strongest presumption. And this court has said in Smith that there is no such thing as one presumption outweighing another. And the court is on the record saying that biology has little weight. It's probably the most insignificant factor. So the district court does two things wrong from an abuse of discretion standpoint. It weighs legitimacy higher than any other presumption, and it devalues biology. And they're supposed to be on equal playing field. That's that subconscious bias. Let's just cut to the chase. I don't mean to embarrass my client or his family who's in the room. This man had an affair with a married woman. They conceived a child. There are people that have a problem with that in society. And I think subconsciously, whether the court liked it or not, it had a problem with that. And it favored a married man over the biological father. You cannot weigh one over the other. They are on equal playing field. And one of the issues that the court did not accept is whether or not biology does have a stronger presumption, but that's not an issue before the court today. That was briefed and argued on the Court of Appeals. But I would more than welcome that debate, but that's for a different time and a different place. The point being, not one presumption outweighs the other, and not one is less than the other.
Did the district court also suggest or indicate in its ruling that it would have reached the same conclusion, notwithstanding the presumption of legitimacy, even if it did not factor that, even without that? And how does that fit into your argument?
It's a convenient way of the court covering its bases. It did say that. That is a concern that we would have from an appellate standpoint that, hey, notwithstanding, if I'm wrong on this presumption being weightier than another, I still would have reached the same conclusion. The problem is, Your Honor, did he ever get the fair shake of presenting with unfettered, non-rose colored glasses, his presumptions? And you can never go and do that. Nothing he could have done. So he's talking out both sides of his mouth. He says, well, I still would have reached the same conclusion. He's on the record saying nothing he could have done. No evidence, quote unquote, could have been presented to overcome that. And that's the problem.
What's the remedy you seek?
Well, there's two things, Your Honor. And in the brief, we ask for a remand.
Right.
If the court says, because it does not weigh evidence, that the evidence isn't controverted, and I don't believe anybody's arguing the evidence. I think there are facts that we would like to argue and emphasize over the appellee, but no one's saying the court completely misapplied the facts, maybe being the birth certificate BAP issue, I'll acknowledge, but you can, if the facts are clear, if you find there to be a misapplication of the facts to the law, take that under de novo review yourselves. But the request that we are seeking is a remand.
A remand for what?
New trial, let this man have his day in court.
What would he say that he didn't say before?
Well, you judge, you would hear that DR and TR are together to this day and have been. The court would hear that since the trial, TR and DR are divorced.
Right, but but that is, so anytime things happen after a district court issues a judgment, you get a remand to hear new stuff?
No, anytime a court of appeals or the Supreme Court finds there to be an injustice and states that a remand is proper, that's when you get it. Just
What's the definition of an injustice?
when a biological father was judged on being a biological father and not having his day in court. That's the bias, favoring the legitimacy of a child born of a marriage over biology, and the court's on the record for stating that. It weights legitimacy and lessens biology, and that is flat out wrong, Your Honor. And that's the abuse of discretion, and that's the misapplication of the law.
But isn't that what the statute says the district court is supposed to do? The district court is supposed to, so many notes here. If two or more presumptions under the section arrive, so your client, submitted the presumption of being a biological father, and then it went over to TR to prove by clear and convincing evidence that there is there's a conflict in these presumptions, and then the judge is supposed to decide which presumption is weightier, considering policy and logic, including the best interest of the child. Isn't that what, so the result was that after considering policy and logic, the district court determined that the presumption of legitimacy outweighed the presumption of biology, right?
Court had stated one presumption was more significant than the other, and it's on the record of saying that. By giving weight to the presumptions of legitimacy, quote unquote, and I did have this memo opinion, record 170, quote, one of the strongest presumptions known to law, end quote. Didn't weigh anything. He said this presumption is weightier than any other. That's what the district court's on the record. And Your Honor, it goes on to say that, quote, biology is probably the most insignificant factor, end quote. That's that memorandum of opinion, record 176. So I wish the court had weighed the presumptions, but it didn't. It had a preconceived bias that one presumption was heavier or weightier than the other. And you don't have to take my word for it. The record says so. And we know that presumptions are to be weighed against one another on a level playing field pursuant to KSA 23.
How do you do that? I see what you're saying, but how are you supposed to weigh presumptions on a level playing field? What does that really mean?
It's going to sound disrespectful to the district court, and I don't mean to sound disrespectful. You're going to have a trial court judge that does not view biology as being insignificant. Have to have a district court judge that is going to have to understand that legitimacy is no different of a presumption from a starting point.
Okay, but if everything's no different, if they're all exactly the same,
Okay.
How do you ever weigh them? Isn't the scale always balanced? You have to decide.
Correct. And that's where I actually think the court might have done something correct in weighing those decisions. And we talk about one of the decisions that the court found against our client that should have at least been neutral or at least in favor of TT would have been the relationship of the mother with the biological child. Together then, ER and TR were divorcing at the time. The court knew it because the divorce was in its own jurisdiction.
Let me
They-
just ask this. What does, in your view, what does the statutory language decide which presumption is weightier based on policy and logic? What does that mean? I think we all generally understand best interest of the child. We can argue about various factors. But what does the weightier presumption based on policy and logic?
Doesn't it say presumptions, Your Honor?
Yeah, you have conflicting presumptions. So the judge under 2208C is supposed to decide which presumption's weightier based on policy and logic.
And I think it's almost as elementary as it sounds. If you were to rear factors and you take 10 of them and 6 favored TT and 4 favored TR,
But aren't those all best interests of the child?
that's based upon the best interest of the child.
Right, but I'm asking about the previous section or previous clause in 2208C, which talks about determining the weightier presumption based on policy and logic.
I believe that is what the Greer decision
Okay.
translates for us.
You don't want courts to weigh these presumptions against each other because your perspective is they're all equal. And now when you have two competing presumptions, you just go straight to best interests and that's it.
Well, this court has said there's no presumption that is greater than another from the Smith decision. So I'm not arguing that. I'm just repeating what the law is and stare decisis of this court. I think this man should have his day in court without being prejudged before he ever stepped foot in court.
And that subsection C that Justice Stegall was just discussing with you, that's not a question of law. It's under the facts, which presumption is weightier. Is that correct? So it can change from case to case depending on the facts.
Absolutely. And that's why, going back to our law school class, you always take the facts of a case and apply them to the law, and apply them to the facts of the case. And if you think about it, perhaps that's what the district court did. Put one presumption over another. Had that preconceived notion in mind. Would have any other questions for me? I've extended my time. I appreciate the courtesy and accommodation. Thank you.
May it please the court again, my name is Tish Warricle. I'm from the law firm of Hampton and Royce in Salina, Kansas, and I represent the appellee TR. I want to jump into a couple of things. The first thing is, no matter what they're saying and how they're trying to shoehorn it in, their argument is number one, biology trumps everything. And number two, the trial court was wrong in how it applied the factors. All of that is what was just said this morning. And Justice, you were talking about shifting one to the other. The presumption first came to my client because he was on the birth certificate. He was married to the person. He did support.
But that's not the way the statute reads. The statute reads that the presumption begins with the person that is trying to establish paternity.
Right, and he was doing that by all of those things. So if a divorce or a paternity case had taken place during the first month of this child's birth, then TT would not even have been a part of that because there wouldn't have been a presumption at that time. They went and had a DNA test behind my client's back in another court. So the notorious acknowledgement that you were talking about can't even really apply because they didn't do it in front of everybody. They did it in another courtroom, in another
The
county.
public record.
Well, yes, but so was the divorce, which was already on file. So, but again, the issue that is being brought before is shifting. We shift from one, we shift to the other, go back and forth. And in their argument today, they were talking about focusing on Greer and focusing on which presumption controls. There are no presumption that control. The trial court is in charge of doing public policy and logic and applying the facts to the case.
Okay, let's talk about that. Okay, policy and logic. Justice Stiegel says, what does policy and logic mean?
That's where I was going to jump to, is
Okay.
just to his statement.
Okay.
Policy and logic. So we can argue best interest of the child all day. Those of us who do family law, we can do that all day. It means all kinds of different things. Policy and logic. Under their version of how this should have taken place, anytime, a third party can come into a marital agreement and file a parentage action. Because under their argument, they're not tied to the legitimacy. They're not tied to the birth certificate. They're not tied
The
to the
birth
VA.
parent. You know, when you're talking about policy, when you look at the district court's decision, the district court says over and over, as appellant's counsel says, and I mean, it's replete in there, and it's based on our case law in Kansas that this legitimacy, which means the child was born in wedlock, it is the policy of our state. Why is it the policy of our state?
Because if you didn't have some sort of a policy, every single child that was born everywhere would have to have some sort of a DNA test to protect the parent, the father, or the intended parent to be.
No, I'm talking about in the context of these presumptions,
Right,
okay?
right. And I am too, because if there's,
It seems to me that, you know, in my research, that the presumptions are to make sure that the family unit stays together, that there's no stigma of illegitimacy, and the state's interest in establishing a source of child support, okay? And in this case, under the facts of this case, how does the district court's decision further that policy? The parents, okay, we won't even say what's going on now because it's not in the record, okay? But at the time it happened, the court was aware. There is no family unit to preserve.
but there's an older child who is also born.
But that's not this child.
Right, but that was one of the factors that was considered because that child.
That was, he talked about that the child would benefit, that was best interest of the child. Talking about the policy considerations with the presumptions, okay?
Right.
There is, I mean, that's the whole thing of illegitimacy or,
Well,
you know, why we do, you know, why we have the presumption of in wedlock is because we want to preserve the family unit. And that the district court knew wasn't happening here. And in fact, the exact opposite, because the evidence was presented that the mother not only preferred that TT be acknowledged as the legal father, but was living as a family unit with TT. So how does this decision further any policy? Give me a policy.
because you have to, when you're talking about policy and logic, and you're talking about the Supreme Court, which we are in front of today, it's more than just this case. You are setting a precedent for everybody else to follow. And that's why it's important for policy. And again, if their argument wins and you decide in that manner, then any child that's born.
Well, I think you're being a little too general because when you even look at the Greer case and the other cases applying this, the birth mom stayed with the presumed father.
Mm.
I couldn't find any case that was a situation like this. So can't we just hold based on the facts of, isn't that what Justice Wall just said? Under the facts of this case, which is the weightier based on policy and logic? And did the court even consider that?
I think the court did, because again, the Parentage Act is what is being attacked today. How do we do the Parentage Act? The Parentage Act applies to more than just this family. Policy and logic of the Parentage Act applies to more. How are we going to do with assisted reproductive technology? How are we going to deal with
Oh,
intended?
no, but we're
parents?
looking at applying this law to the facts of this case.
Yes.
And when we talk about policy, let's talk about logic, okay? I don't even know how you define logic. I hope I'm logical. But how would a reasonable judge find it logical to deprive a birth father of his child when the minute he found out, he went to the courthouse, he's living with the birth mother, and he wants, has been actively pursuing a relationship with his child?
Because biology is not destiny, and by this.
Right,
court has-
I'm not saying it is,
So
but under
by-
the facts of this case, how can that be logical? That when that kid grows up, he's like, oh, you're not my you're not my birth dad, but you're my legal dad. So you get to make decisions about everything about me. And my birth dad over here, gets chopped liver.
How is that any different than an adoption? How is that any different from a parent who, let's say, a biological father comes in and is barred in an adoption? It's not any different. In an open adoption.
When is
the
a
child-
biological father ever?
If they do not act timely, they can be barred.
But that's not the facts of this case.
Right.
The facts of this case is TT. I mean, he was Speedy Gonzalez here,
Yes, but again, my client didn't know that. It
right? Which
took
is
him a
another
while.
whole thing about acknowledging paternity when you're, was that decision even based on full disclosure? Because would he have acknowledged paternity had he known?
Good
Right,
question,
so-
but we don't know that because
Right, we
that's not
don't know
the
that,
facts
but
of the
you're
evidence.
right, but you brought it up. So
Right. But again, my client didn't know that.
I just don't,
Supported-
I don't see the logic of this. And, so what evidence supports the district court's conclusion that would be in the best interest of the child for TR to be the legal dad?
Well,
He has the brother,
he
okay,
does,
but of course the brother's going to go back and forth every week.
right?
So that's, so it's a difference between a stepbrother and a half brother.
Right.
What else?
It's also the facts that he had supported this mother during her pregnancy. He was there during the birth. He was there after the birth. He went all through those times, and it was not until something was done that he didn't know about, that he found out about, that he had any chance to say, now, wait a minute.
So
Now,
his rights trump biology.
I'm not saying Trump. We go back to that shifting again. And we have to look at those shifting parameters and those shifting weights. And one of the things I wanted to point out about something that you had asked about, had the judge actually said that on the record. He didn't say no evidence, period. He said no evidence presented would have made me change my mind. So nothing that was presented made him change his mind, not no evidence at all. Read his sentence, it's no evidence presented.
Just.
That's very different.
Was that statement, which everyone has talked about, that the judge made prior to the presentation of evidence or after the?
That was in
presentation?
his decision.
Okay, that's what I had thought.
Yeah, it was in his decision.
Does the mother's preference come into account in policy and logic?
I think it does. It's just one more thing.
And
Best-
enabling the kids to know, to actually have the community recognize who their biological parent is, that policy and logic?
Well, at this point, looking at this facts of this case, cat's out of the bag.
Right.
It's a small town. People already know. But
So what kind of stigma is that gonna be for the child?
there's going to be stigma for that child no matter what.
Why?
Well, because. if
Why
you-
would there be stigma if the birth dad got legal custody?
Because this is going to be, it's a small town. People are going to know this situation no matter what. No matter who won, people was going to know these situations. It was going to be a stigma either that he was born out of
But-
wedlock or, and I'm not saying that's right. And I'm not saying that'll
No.
apply in every situation. But the facts of it, if this had happened in Wichita, it would have probably been a much different situation, because looking at the facts of this case, this child's always going to know that this man is a part of his life.
Not really, because if you think about the impact of this decision, Okay, for now, we didn't know coming in here and it's not in the record, so we're not going to consider it
Mhm.
that mom and TT are still together. Okay, but tomorrow, let's say mom leaves TT.
Doesn't that make it even stronger that the family unit of a divorced family with two children?
How can
be
you
together?
call a divorced family a family unit?
Because divorced families are family units. They have to co-parent. They have to raise those children together. And one thing I always tell my clients is that it doesn't matter if you're not husband and wife anymore, you are always mom and dad. And your product to this world is that child.
Couldn't you say the same thing for TT?
You could, but again, the trial court did not decide that. And we're looking at abuse of discretion. Was there abuse of discretion? And they focus on the Greer, but I'm glad that you popped up on that really quick, because Greer at this point doesn't really apply to you guys. You can make a different decision. You can say Greer was incorrect. But again, they go through step by step. And even in the argument today, they said, well, if we look at it, 5 factors were for us and 4 factors were for them. So on a pure numerical status, we win. That's not how best interest of the child works. You have to look at the entire thing in the situation. And that's what the judge did in this situation. I wanted to,
Really do want to hear what you have to
Okay.
say, but I'm puzzled. We're uncomfortable with the Greer factors, recognizing that's the first time that have that. What do we do about? Let's just say we wanted to add a few. Don't we have to send it back to the district court to apply, having heard the facts and all that? And we have to send it back to apply those new factors to the calculus to see what the other side.
I think it would depend on what you decided. If you decided that rather than adding a few, say, yes, this is in the right order, but the legislature has looked at this, so we want to keep this all in consideration as well. Maybe, maybe not. I think it just depends on how you come down on that in your discussions with each other. But where I was headed was there was a case in 2022 in Ray AK, and that's a court of appeals. Doesn't apply to you, but in reading it, I was just struck by many things that happened. Because what it said is the court must avoid giving veto to one party after arrangements have already been made and put in place. In this situation, the arrangements that were made and put in place at the time this child was born, and at the time that those parents, the married couple, were there, is that we are parents. We are mom and dad.
Okay, so what are,
And that, I'm sorry, I don't mean to interrupt, but that's where you get into the shifting.
no, I get that. So extrapolating from what you're saying, if a man has a baby with a woman who's married and the child is birthed within 300 days, whatever, and married, under what you're saying, there could be no facts, no nothing where the bio dad could.
No, because there's also a position in there that says unilaterally. So if the parents together decide, somebody just can't unilaterally change their mind at the last
Okay,
point.
so if the husband anoints and says, I'm granting my permission, but beyond that, there is no way in today's world that a bio dad can become the legal father. That's what you're saying, right?
No, that's not what I'm saying at all. I'm saying it's one of those shifting
Well,
parameters.
give me an example of what TT could have done differently.
Well, if he would have thought that this child was his, it should have come out sooner. It should have come out during the pregnancy.
But
during
the
all of
stuff that you're saying, it wouldn't affect anything based on the trial
But it
court's
would have,
decision.
because then he would have had a presumption right away if he would have helped support her during her pregnancy. That's one of the things in an adoption situation. You have to jump on it to.
But doesn't the
protect your
person
rights.
have to know that the person's pregnant with their child?
But if they have a continuing relationship, which it appeared that they did, how would he not know? How would he not know that she's
Because she
pregnant?
could be sleeping with her husband at the same time. It happens all the time.
I'm not saying that it's for sure. I'm saying that there's a chance. And we do the same thing in adoption situations. You have an obligation, if there's a chance that that child is yours, you have an obligation to support the mother during the pregnancy. Why is that any different in a marital situation? If somebody had an affair, If
Well-
they think that that child is theirs and there's a possibility, shouldn't they be supporting that child? How is that any different?
Well, because number one, I mean, our cases have held that the father needs to know she's pregnant,
Mhm.
right?
Father needs to have a suspicion that she's pregnant. It doesn't have to be 100%. You're saying that in this small town
Okay, so,
where they're continuing a relationship, he didn't know that she was pregnant.
okay, so, but mother wanted in the first 3 months before husband filed for divorce, said he wasn't gonna, she wanted to stay with father, right? That's the evidence in the record.
Up to that point, yes. Well, as far as we know, yes.
Okay, but you're saying TT, even though that he should have been saying, oh, let me send you a monthly check of $500.
Again, how is that any different than the adoption situation?
Because we're not in the adoption, we're in the
But
Kansas.
again, it
parent-
goes into policy and logic. If
Well, if
our
we're gonna talk about
policy-
policy and logic, we could talk about how many states have adopted the 2017 KPA and look at completely different factors. So is that policy?
But we're
And
not
then
there yet.
also, you know, we're looking at logic. How is it logical? I can't get over that. How can it be logical that a man cannot parent his bio child?
And again, you go back to policy. If again,
And the policy is we want kids to be legitimate, but that's not, that's an antiquated policy.
the policy is we want kids to be supported. I agree with you that legitimacy
No.
is not as high as it has been in the.
Well, the district court said, and appellate's counsel is right there, that that is the strongest and ancient, oldest presumption that there is. So the district court didn't agree with you.
Well, I think the district court did it under the presumption shifting. Because again, in terms of time, which presumption came first? Legitimacy came first. That's the first presumption that came.
Where does it say that that there's a timing issue?
No, but if you go into the shifting, how are you going to start shifting?
Okay, shifting means that, you know, here TT said, had to file the petition for paternity and say, look, I'm going to meet my presumption under subsection, whatever, that I'm 99.9% the dad. And then it shifts over to TR and he says, yeah, but I was married to her at the time and I signed the application. Okay, and he has to prove that by clear and convincing evidence. Okay, which he did. And so then it goes back to TT, and only by a preponderance of the evidence has to go into that, which is weightier based on policy and logic. That's how I understand.
And I wanted to go into that a little bit. And the Court of Appeal, I also did not try this case. Had I tried this case, I'd have done it a little bit differently. Because under the appellate court did not take the argument of the fact that the Ross hearing was never held. Okay, so if there had been an appropriate procedure in the underlying part, what would have happened is first there would have been a hearing on, is it appropriate to even recognize this?
But that ship sailed. So we're into presumption territory now.
But we're going into policy. You're asking about policy. The policy of the state as it exists right now is there should have been a Ross hearing. That's the policy of the state. And at that point, before a DNA test was ever even taken or even allowed to be admitted into evidence.
How is that based on logic or policy?
But that's the law. that
Especially when the
exists right now.
parents broke up.
I understand.
How is the Ross hearing, though, realistically going to turn out when the baby is?
Well, and again, this is one of the cases or one of the situations that I'm glad you took up because this has been about the 5th case like this that I've had in the last 2 or 3 years, where there's an issue about biology versus a parent who thought they were the parent. And that's the question. And as I've served as a guardian ad litem before, and I have said biology means something, we need to go ahead and let that DNA test come in. And I've had a court say, no, you're wrong. In this situation, child's under 1 year old, they've been serving as parent, that person is parent, period. And that's even in a situation where a parent didn't want to be a parent anymore. So Ross is still valid until you say that it's not.
Doesn't the Ross hearing address the relationship of the child to the parent in addition to the child?
Absolutely, absolutely. But you're talking about a presumption of biology. If the Ross hearing had been taken, there wouldn't have been a presumption at there. It would just been a question of that. So that's why I say I tried the case that had run a little bit differently, and I'm sure my opposing counsel believes that as well, so. I think you can consider whatever you want to consider on your own motion. And
Has it
I'm
been
not,
argued? Has it been argued, presented?
it was presented in the Court of Appeals. They chose not to address it since it was not addressed at the top.
Is it before us? Is it before us?
No, no, it is not. And that's my time unless anyone has any other.
What is the, I guess I do have one question.
Okay.
When we think about policy and so on, what lies behind the presumption of legitimacy? And I don't mean the policy of the family union and so on, but what is that presumption actually presuming?
It's presuming that a married couple's child is that married
Right.
couple's child.
I think that's right. In other words, it's presuming that the husband of the mother is the biological father.
Right,
That's what it is presuming.
right.
And when we have DNA testing that conclusively demonstrates that to be false, doesn't that play some role?
I'm not saying it doesn't play some role, but when you're talking about policy, if what you're saying is someone can come in with a DNA test and overturn a relationship that has already started.
Well, that's practical. I'm thinking more sort of ontological, like what is the point of the Parentage Act? And the point seems to me to be for the law to figure out who is the biological father.
I disagree with that. The point is to figure out who the legal parent.
Well, that's the ultimate conclusion, but that's why I asked my question the way I did. What is it that's actually being presumed? And what's actually being presumed is not, who's acting like a father. It's who is it's biology, isn't it? And you acknowledge that in answer to my question.
Well, and I understand where you're coming from, but to add to that a little bit, again, we have all these situations in modern day society where there's two parents. Maybe neither one of them is a biological parent. So there was the case, and I don't remember, let me see. I think it was in front of you where the grandparents asked for permission in a parentage action. And the court said, nope, that's not it. You have to be a parent or be acting as a parent. It didn't say you had to be a biological parent, it said you have to be a parent acting as a parent. Thank you very much.
May it please the court. In my 3 minutes, I want to answer two of the court's questions, one of which was asked of me, and I was ill prepared, and I apologize, and one of which was asked by Justice Stanridge. Kelly. First, with regard to Justice DeGaulle, the site for the record is Memorandum Opinion 3, Record Volume 1 at 69. And I'm glad that you made me pull it because I want to point something out. The court began its discussion in its ruling, quote, something of note. It is the court's belief that TR is currently the legal father of the child. He was married to the mother at the time of birth, and he has acknowledged his paternity and application of the birth certificate. If TT had not come forward in an attempt to undo the voluntary acknowledgement of paternity and the presumption of paternity pursuant to marriage, this relationship will not changed, and it can only be changed by the court's decision in this matter. It is the duty of this court to take the factors set out in the Farbo versus Greer and any other factor relevant to the best interest of the child to determine if the court should undo the current legal status of the father in regards to TR. This court will discuss this more fully below, but the court is of the opinion that no evidence presented at hearing would compel the court to believe that it is in the best interest of the child to undo the current legal status of TR as the father's child, despite the biology of the child. And the point that I was trying to, end quote, and the point that I was trying to make is that I don't believe the court appreciated the fact that because TT signed the voluntary acknowledgement of paternity, he is allowed to present his competing presumptions on a level playing field. And that was the cite to the record. But Justice Stanridge asked perhaps.
I asked a short question. The judge said that after he had heard the evidence.
He did say that, but the point of the matter is undo the legal status. Required to make an independent analysis when non-signatory to the VAP is asking for the court to consider competing presumptions of paternity. This court has already determined that, and so does the statute. Justice Standridge asked smartly more than once the question, what does weightier considerations of policy and logic mean? But he gave you a great answer. Let me try to answer the question from your contemporaries at the Court of Appeals. In the Greer decision, the Court of Appeals went on to provide relevant and helpful guidance for weighting the competing presumptions. In Greer, Your Honor, at 193 through 194, here's what the Greer court quoted. A few courts around the country have tried to parse the considerations of policy and logic language. The Wyoming Supreme Court noted that this language is not only limited to legal policy, but quote, clearly implies that a court should consider broader sociological and psychological ramifications of its decision as to which man should be adjudicated the legal father, end quote, and it provides a cite. The Greer court goes on to talk about the Minnesota Court of Appeals, and it said, quote, Minnesota Court of Appeals observed the statutory language embraces, quote, the policy of not unnecessarily impairing blood relationships, end quote, and requires that the outcome be, quote, logically based on the facts, end quote, and provides a cite. Appropriately, policy and logic portion of the inquiry appears in part to be heavily based on a state's individual case law and policy. And it cites an Alabama decision with regard to that. So what don't we have in Kansas? Have that other than the Greer decision. And it was looking to other Supreme Courts. But look at those two quotes, the broader sociological and psychological impact, but yet this court said, well, this child's only 18, must stop the analysis there. Never know. Never know. And not unnecessarily impairing blood relationships. So when the Greer court was asked that very question, Justice Standridge, that's how it answered. That's the best that I can give the court today. Does the court have any other questions for me?
I do, just in terms of the whole notion of legitimacy versus blood. And I'm talking about legitimacy, and that seems to be reflected in the statute. Is that something for us to weigh in on the policy aspect of that, or is that something for the legislature? Because societal norms have changed drastically over the last century, over the last 50 years, to where we have current. The whole notion of stigma seems to me to be different than it was maybe even 25 years ago. Most children are born, I don't have the exact statistic, but most children are born from a mother that isn't married. So how do we factor in that without guidance from the policymakers and not us?
I think I said earlier, Greer was decided in 2017. It's actually decided in 2014. In Greer, the Court of Appeals notes that very thing, and it says several changes to the KPA since Ross in 1989 and Greer was decided in 2014. And it goes, quote unquote, the applicable provisions of the KPA have changed dramatically since Ross and perhaps in part in response to it. And it goes on to talk about how we changed how we consider genetic testing, legislatively speaking, in 1994. The only point that I would offer rhetorically to that question is the reason legitimacy matters is we don't want to bastardize a child, but that was never a risk that was ever going to happen here. Here's two guys saying, let me be the father.
But the term you just used, bastardize the child, is that seems to me just an antiquated term. Do we ever even talk in terms like that, except for what I just heard now?
It's not my term of art. It's been recognized.
I know, I understand it's not your term of art.
A child born out of wedlock. And that was, and not having a father. And that's not what we have here. So legitimacy could never have been, under the facts of this case, a weightier presumption when there's two fathers saying, let me be the guy.
Can I ask what to me seems to be a related question, which is, in this case, was it ever argued, or did the district court ever consider the definition of the father-child relationship in 23-2205, which defines the relationship as the legal relationship that exists between a child and the child's biological or adoptive father.
I don't believe it did. If it did, Your Honor, as an officer of the court, it's forgetting my memory, and I know this case awfully well.
I have one clarification. So I know that there have been changes to the Kansas KPA. It's like genetic testing, but the statute we're looking at now, am I right in saying that the last time that it was amended was 1994?
Are you talking about 2208, Your
Yeah,
Honor?
I am.
1994, and that's
Right.
the statute discussed in Greer, and what
Right.
the real only change was regarding genetic testing.
And then the other question is, so to Justice Rosen's question about, isn't this policy consideration something for the legislature? If the legislature writes a statute and tells the court to consider policy and logic, isn't it kind of assigning that task to the courts? I mean, normally you say, we don't make public policy. We apply the law to the facts. But in this case, it's a very unique statute where the legislature is telling the courts, you decide based on policy and logic.
I can't argue against you. The only thing that I would answer you back on is it is not uncommon, especially in domestic court, this court to step in and help interpret what that time when it talks about the best interest of the child. How many times has this court been asked to consider the definition and provide clarification as to the best interest of the child? How about what justice and equity so require when considering the issue of spousal maintenance? And the list goes on and on. We often rely upon common law to help determine and define difficult issues of law or questions of law.
Along those lines, just an anomaly that I'm wondering if you know why the 2208 lists the DNA probability at 97%. Why is that?
I don't know the answer, but there happens to be a gentleman in this room that could answer that, but I don't know that.
Well, let me posit a guess, which is because when the statute was written, that might have been where the threshold scientifically was at.
And if you go back to yes.
And so my follow-up would be, it seems to me that there's a big difference between 97% and 99.9999%. And should that come into play in how we interpret the statute?
If that was a concern, then I think you might get into a Ross hearing. I would have taken exception to the notion that a Ross hearing was required. And the reason I take exception to that is genetic testing was done before they ever went to court. The Ross hearing would be all about whether or not we need to do genetic. So if the court is concerned with 97 versus 99.9.
I'm going to push
One
back a
being-
little bit. Doesn't it actually mean whether or not the DNA result will be considered by the court?
And I would tend to agree in part with the appellee's argument that biology isn't the everything. In fact, this court is replete with telling us multiple times, starting with the Ross decision, that biology is a presumption, it is not the presumption. I am certainly not telling the court that biology must be the end.
What does that mean when you look at the definition of the parent-child relationship, which explicitly says it exists between the child's biological or adoptive parents? That's what it says in the statute.
I would tell you, Your Honor, if you have the peripheral 50-50 or equal coin flip, that the coin should be weighted in favor of the biological father. That would be my answer to that question based upon the statute. And I would say the legislature gives us that guidance. And then I would double down and point out the statute that I already said, that marriage in and of itself doesn't matter as to the father of a child. And that's 2208, I believe I've read into the record for the court. So that's how I would answer that. Those two questions, conclusion is why I have and my client has the heartburn that legitimacy was given this much weight and biology was given the least significant weight. And that's straight from the district courts. Thank you for your time.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. What that means is that the court will begin discussion of the outcome of this case later today. And we will continue that one of the justices will be assigned to draft an opinion that will be circulated among the entire court. We will continue those discussions and the editing and redrafting as necessary until we reach a final decision. At that time, the court will issue a decision. It will be made public on the Kansas Court's website as well as through news releases. With that, at this time, the court will be in recess for 15 minutes until approximately 10:35.